Large preparation for this. So, what are the grounds for informed consent? So, two grounds are, one is ethical and other is legal. The patient has a right to being done on the, that is, patient has to give consent for you to do any intervention with him. So without his consent, if you touch the patient also, even if you examine the pulse, that is considered as a crime called a legal battery. Okay? So informed consent is grounded on ethical and legal concept. The patients have the right to being done to what needs to be done to their bodies and agree to the potential consequences, that is self-determination and self-decision. There are two law battery crimes. First law is the performance of a procedure, unauthorized touching without valid consent. The second is negligence or failure on the part of the healthcare professional to warn the patient of the risk. So these are the two things which were involved in the informed consent first. And the consequences of failure to absent informed consent may result in compromising the patient autonomy, increase the patient safety risk due to incomplete patient clinician communication, and it may constitute negligence, may constitute, as I said, battery or a crime, breach of contract, and it may lead to the clinician landing up with professional disciplinary activities. And the benefits of a proper informed consent, if you have taken a proper informed consent, it is a robust patient-centered informed consent is a model of shared decision making. So it enhances patient safety, improves patient satisfaction, that we have explained everything to him and they are aware of it, meets the ethical and legal duty to the patient, and increases the staff morale, that you have not missed out on anything, reduces the legal risk to healthcare provider and organization, and also ensures compliance with regulatory and accreditation requirements of the law. And so informed person must be in a signed form. The anesthesia professional and patient develop the anesthesia plan through discussion of alternatives and risks and benefit of the plan. Now, what are the elements of the informed consent are? First is the competence and decision-making capacity of the patient. This is a very important first point. The patient has the legal authority to consent, which is called the competence. He only has to give the acceptance, and his ability to decide whether it is whether he has understood what is being told and whether he has taken the decision on his own is the capacity. So both are not the same. Competence and capacity are not same. Competence is the legal authority for him to give the consent. And capacity is for him to decide whether what he has accepted is right or wrong. Then disclosure of information is the second element. Patient is adequately informed of relevant information and the nature and purpose of proposed anesthesia technique or technique, its benefits and alternatives, and the risk of not receiving the anesthesia care, all has to be disclosed to the patient. And the next step is what you have told the patient should have been understood by the patient, understanding the disclosed information. So the patient demonstrates understanding of the information disclosed by the anesthesia professional. Then the fourth part is he has to give the consent on his own without any coercion or compulsion. Don't say if you don't get operated for this hernia, your bowel may get caught, may get strangulated, and you may die. That sort of threatening should not be there. You have to explain all the complications, but at the same time, it is the patient who has to decide on his own. And he may say, I will get operated after 3 months or 6 months. You cannot say, no, if you don't get operated tomorrow, day after tomorrow, you are going to die. That sort of coercion should not happen. So it should be on a volitional basis by the patient. So patient voluntary consents to the planned anesthesia and surgery without coercion and duress. And the last component is the documentation. Health record contains appropriate documentation, evidence the patient's informed consent for anesthesia. So those five parts have to be first employed. Now, just for explanation, I am giving this. But the second part of the question, who are exempted from this, is important. So, competence means it refers to legal authority. We have already said. So, most states consider a patient to be competent, unless otherwise determined by the court if they are not competent enough. For example, minors, people who are not attained the age of 16 in Western countries, and for our people it is about 18. So they are not considered as people who are competent or have the right to give their consent. But depending upon the intelligence of the minor, you sometimes courts accept their consent also. Like if they have already got married or engaged in military service or living independently of their parents, and if they are pregnant or high school graduates seeking special healthcare treatment, all these people, even if they are minor, their consent is considered as valid. So even if a minor does not have legal authority to consent, he or she should be included in the informed consent discussion if developmentally appropriate. That is, if they show maturity enough to understand what is being told and if cooperation can be sought. And the second part is the decision making capacity should not be confused with competence, as I said earlier. And this is ability to make a meaningful decision on his own without undergoing any problem. Then the anesthesia professional evaluates the patient, determining the capacity, and they will make the decision by considering the medication effects and patient's demonstration and understanding. And the if the patient's mental capacity is not up to the mark, then you can do what is called a mini mental state examination or seek a psychiatrist help and take it before you discuss with them and give them the right to decide. It is the competence to uh, decision making. And, and once the determination is made, we give the document the determination of the patient's decision making capacity, and patients who are become incapacitated do not lose their right of informed consent when decision making authority is transferred to a legal decision maker or a who are called surrogate decision makers. I'm sorry. Uh, so this is particular part is for people who cannot have a cognition and then decide on that. That also has to be included. And what is disclosure information and why it is important is information that is relevant and helpful in making meaningful informed decision is very important. And it begins with the explanation of the patient's decision making and it continues as an interactive process. So you have to tell everything and allow the patient to ask any questions or doubts if he has, and encourage them to discuss with you so that you can completely clear all their doubts before they give the consent. And information is applicable to anesthesia care about goals of care, possible recovery concern, and post anesthesia period also has to be discussed. And so the majority of the jurisdictions use a reasonable person standard to say that they are competent enough to give the consent. And what is special consideration occur in disclosure? Disclosure of unplanned conversion to general anesthesia. This has also to be given. For example, you start a case under spinal, and unfortunately, surgery prolongs beyond the duration of spinal anesthesia, and the surgeon has not finished. At the time, you may need to convert it to general anesthesia. So, unless it has been told to the patient that there may be a need to convert your regional technique into general anesthesia in case it gets prolonged, then the patient can take you to the court of law. So this disclosure is very important whenever you plan to do a procedure on regional technique. Always say that there is always a chance that the technique may fail and we may have to convert it to general anesthesia, or the duration may get exceeded and we may have to convert to general anesthesia. So that caution should have been told to the patient, and the need for that may happen because of failure of the block or the prolongation of the surgery. And why the patient should understand the information and what are the effects of that is, patient must demonstrate an understanding of the plan of anesthesia in order to make an informed decision and decide whether to receive anesthesia care or not. The variables such as language, cultural, religious belief, and health literacy and the health impairment are very important for understanding this procedure. Now, what is voluntary consent? The patient should not be under any stress or any compulsion to undergo that. So that is the importance of voluntariness, and patient has the right to withhold the consent, or he can revoke the consent. He may say yes to particular procedure. For example, you want to do a total knee replacement and you explain the patient about regional anesthesia like the axial blockade and he agrees. But he has not signed the consent now. And the night somebody relative comes to see him and say, hey, don't undergo regional. I underwent and I am still suffering from backache. Some sort of things could have been told, or he could have even signed the consent, and then the next day morning he says, I don't want a regional, I want only GA. So patient has the right to revoke the consent, provide consent after initially withholding the consent also, whichever way he can. Then documentation is very, very important. How the documentation has to be done. Following the interactive development of the anesthesia plan, the patient or legal decision maker should give the consent to anesthesia and sign the anesthesia informed consent document indicating the date, time, and relationship. And the informed consent should not be signed until the patient's questions have been answered to his or her satisfaction. So you must repeatedly ask, are you clear about all your explanation what I have given? Are you willing to now confirm and proceed with the consent? Then only you should be allowed to sign. And those who sign as witness should make sure that they saw the patient or patient's legal decision maker sign the document, and identify an appropriate available witness should be there, and they should also note the date and time. And if significant changes to the agreed anesthesia plan occur after the patient is sedated or anesthetized, the reason for change should be documented in the anesthesia record. This is also a very important point of that. And finally, formal documentation of informed consent provides evidence. And this is the most important legal document that will protect you in the court of law, and let me protect the professional from legal liability. Why? When should the anesthesia informed consent be timed? The process form should be based on the patient's current health status, and any change in patient's condition after he has completed this should again be revised because the risk and benefits alternatives will have changed. For example, you give assessment today and surgery is planned for next week, and in between patient develops a temperature and it may be a UTI. So for an elective surgery, this may interfere with that. So what consent or what agreement the patient has given 1 week back will not hold good because now the patient's condition has changed. So the timing is very important, that once given, it is not a blanket consent for the, unless the patient condition remains the same, it cannot be taken as a proper valid consent. So the patient's status and health status should be the same after you have taken the consent before you do the anesthesia and surgery. And what is to be done if it is emergent to do the surgery to save the life? Immediate treatment or intervention, supposing patient is unconscious or incapable of consenting, then It is implies that you can go ahead and do that in true emergency. It is implied that consent is not required and it is granted that it can be done. And emergency should be documented in the patient's record. That is the most important thing. Why you are going ahead without the patient consent should be documented. And to secure the consent of the legal decision maker or his legal relative after the patient stabilizes also should be done in the document. So that even if it is a later consent given, that should be documented. And what can the health profession, when can they withhold any information? The patient may limit the scope of information they wish to receive. So the withholding of information is only done by the patient, not by us, because our duty is to explain everything in detail to the patient. But if the patient says, don't tell me any gory things, that I will put a tube in your throat, the time your teeth may break, if all these things I don't want to hear because I already read it somewhere. So if patient says, I don't want to have any information, then you can withhold. Otherwise, you have to give every detail to him, and it is within the legal limits of the patient to stop learning or avoiding any information that is given. So the right of not listening to any information is with the patient. That is the particular thing that you have to understand with this particular question. And what are the special situations that have different conditions for obtaining consent is critical care and emergency. Jehovah's Witness patients who don't accept blood transfusion, they have to give a consent that I don't want any blood transfusion, even if I die. That sort of information should be there in the consent, and they should sign. And obstetric patients in an emergency, chronic pain treatment, or patients with research work and who are being subjected for research work and teaching, all this information will be slightly different and more detailed, and adequate witnesses should be there to get the consent. And these are the final guidelines for the informed consent. It should be for a specific procedure. For example, if you do a hernia surgery and unfortunately you have to do an orchidectomy because there was some injury to the spermatic cord, then the orchidectomy becomes a secret procedure. So, but you may have got a consent only for hernia repair. So, the consent will be valid only for hernia repair, and orchidectomy has to be included later because of the complication that has been happened. If you have explained that complication and told the patient, and you are doing it because of the necessity intraoperatively, then that can be added as a further procedure. But if you have not told about this particular complication and you do orchidectomy without his knowledge, then that becomes a liability and a legal problem for you. So it should be for a specific procedure. It should be given voluntarily by a competent patient. And, complication, all of them, however least likely, that has to be explained. And risks related to patients' comorbidities should be explained, like what can happen if you have hypertension or uncontrolled diabetes and all those things. And adequate time should be given for the patient to read and understand the consent form. And the honest answer should be given to patient questions. And patient should be given the choice to choose from various anesthetic options. And whole discussion and patient decision for intervention should be precisely documented in patient's vernacular language or the language he understands. The patient should sign the form after carefully going through that. So these are all the guidelines that are given for the completion of that consent form. So I think you have to add all those points to your answer. Yeah. Even though it's a very boring question, it is very often repeated in the theory. So I think you have to. I hope I have made an attempt to make it as clear as possible. So the components, then the method of describing competence and consent, and the exceptions, the unusual conditions, and the final guidelines. And never forget documentation. That is a very, very important safety precaution that you have to remember, uh, not only for your exam point of view, but in future also, wherever you go for practice. Of course, in corporate hospitals, it's all routinely done by the nursing staff and other people. But in small nursing homes or in your own nursing home, you are going to practice, make sure that everything is documented so that you don't get into any legal side. Okay?
Yes, sir. Understood, sir. Thank you, sir.
Okay.